Hello, my name is Glenn Bates. I'm an attorney with Woods and Bates. If you're watching this video, it seems likely that you're going to be meeting with one of our attorneys soon to discuss some estate planning. I want to give you a little bit of baseline information about that and what to expect when you come in. So what we're going to discuss with you is some estate planning, and there's different ways to do that. And a couple of the most common ways are will-based plan versus a trust-based plan. So in a will-based plan, you're going to have what's called a last will and testament, and that's a document by which the person directs his estate to be distributed at death. So that will, when somebody passes away, goes through what's called the probate process, gets admitted to probate. The executor, who's a nominated person in that document, would be appointed by the court. That executor is going to wind up the affairs of the deceased. So they're going to collect assets. They're going to protect those during the estate administration. And then they're tasked with distributing those according to the terms of the will after the debts have been paid. That will can also do things like nominate guardians, or it can create trusts in the will after death for minor children, things like that. Is a little bit different from what we call revocable living trusts or a trust-based plan. In a trust-based plan, what we're talking about here is revocable living trust is a trust that's created during a person's lifetime. What we do is we take the assets that that person owns and we retitle them into the name of the trust. The trustee is going to be appointed in that document. So trustee could be a person, a friend, a business, a professional trustee. Usually that's going to be who's creating the trust at first. Then we're going to have a successor trustee to that person. In a revocable living trust plan, we avoid the need for probate if it's done properly. So if the trust is funded with all the assets, we can hopefully avoid having to probate the will. There's still going to be a will. In that case, it's going to be called a pour-over will. That's going to act as a safeguard to make sure that everything gets to the trust in case something wasn't actually titled in the name of the trust. But we hope that we won't have to probate that will if we've done it correctly. There's pros and cons to both of these. Just real quick, if somebody dies without any type of plan, they're known as dying intestate. By coming in and meeting with us and working on this plan, we're avoiding that scenario. We don't want the state to determine what's going to happen when we die. Real quick here, just a comparison chart of will-based plan versus a trust-based plan. The costs in a will-based plan are lower up front. There's less work that needs to be done versus a trust-based plan. There's higher upfront costs because there's more work. In the same vein, there's a lower time commitment to a will-based plan, more time commitment to a trust-based plan because we're retitling assets. We're funding the trust with things. So there's some work that the person that's creating the trust has to do. The will doesn't do anything until you're deceased, whereas the trust is going to nominate the trustee who's going to control those assets even when you're living. After somebody passes away, there is court involvement with a will-based plan, where with the trust-based plan, there's not. Again, hopefully we're avoiding probate. We have a little bit higher cost with the will-based plan after death versus a trust-based plan that's done correctly. There's minimal cost, hopefully minimal time commitment. The estate administration process of a will can be more time consuming. There can be some delays in that administration process. In the trust process, there is not any delays. And privacy. When a will-based plan, there's not going to be any privacy. Those records are public. In a trust-based plan, the only people that are entitled to see those are going to be the beneficiaries and any creditors that the person might have. When we talk with you, we're going to talk with you about ownership and beneficiaries. We've asked you to submit some of this information already. How your assets are owned, whether those assets list beneficiaries, that all becomes important on creating your plan. Joint ownership, anything that lists beneficiaries, transfer on death designations, those are all going to take precedence over what a will says. So we want to make sure those are all in line with what the plan we're creating says. This is important to keep in mind. It's important to review from time to time. We're going to go over those things with you to make sure that your plan aligns with the ownership of your assets. Just real quick, the assets that we talk about are non-probate assets versus probate assets. In our non-probate asset section here, we have joint ownership. If you own something jointly with someone else, that asset's going to go directly to that joint owner when you pass. If you have the beneficiary listed, that beneficiary is going to inherit that asset when you pass. Or if it's owned by a trust, the trust is going to say where those assets go. So those are not things that are going to be probated. Those are not assets that are going to be controlled by the will. Probate assets, or assets that are going to be controlled by the will, are going to pass according to the will, if we have one. So here in blue, the will is going to say, here's who I want to have these things. So that's who's going to inherit. And if there is no will, the statutes of the state of Illinois say, here's who your heirs at law are, and those are the people that are going to inherit when you're gone. Again, we're going to avoid that situation because we're going to create a plan that says where you want things to go, and we're going to execute that plan. We have a lot of things that we consider. Do we need to limit estate taxes? Where do we want things to go? Do I need to protect my heirs? Who do I want to act as executor or trustee? What if they can't act? Do I need to have a successor? If I have minor children, who do I want to care for those people? Should I create a trust for them? Do I want to make any specific bequests? So these are the things that we're going to get into, that you're going to tell us what we need to draft in order to make your plan effective and make it do what you want. So we look forward to seeing you. Hopefully some of this information is helpful and we can discuss it in more detail when we get together. If you have any questions in the meantime, our telephone number is 217-735-1234. See you soon.